Good afternoon, everyone. My name is Mike Strozinski, and I'm Executive Vice President and General Counsel for the Massachusetts Health and Hospital Association. On behalf of the entire team here today at MHA, I'd like to welcome you to today's webinar, Complying with the new Massachusetts Pay Transparency and Pay Data Reporting Law. A few logistics before we start. If you have questions during the webinar, please enter them into the chat feature as we are in a listen-only mode. The questions will come directly to us, and we'll do our best to address as many as possible prior to the end of the presentation. I also want to take a moment now to thank MHA's 2024 sponsors for their support in underwriting today's webinar, which is just one of many events we have to offer throughout the year to connect our members with leading experts on timely issues such as the one today. I'm now pleased to introduce our speakers from Seyfarth and Shaw, Kristen McGurn and Barry Miller. Kristen is a partner with a specialty in labor and employment. She's an experienced litigator who helps businesses mitigate risk and navigate employment disputes with a practical, business-focused approach. She advises clients on employment matters throughout the employee life cycle, from onboarding to separation, and has successfully handled complex class actions and agency litigations. Kristen's expertise spans federal and state employment laws with a focus on wage and hour compliance, Title VII, ADA, and FMLA. She works extensively with healthcare, pharmaceutical, and other industries, drafting contracts, policies, and defending against employment-related disputes, including ERISA claims and agency enforcement actions. And we know her well here at MHA as she's provided us with many, many years of expert guidance. Barry Miller, Barry Miller is a partner in labor and employment. He focuses litigation on defending complex wage and hour claims, including collective actions under the Fair Labor Standards Act and state class actions. He successfully handled cases involving misclassification of workers, wage disputes, off-the-clock work, and all phases of litigation. In addition to wage and hour matters, Barry represents employers in discrimination, harassment, and whistleblower retaliation claims, as well as non-competition and breach of contract disputes. He also provides compliance advice on employee compensation, disability accommodations, and terminations. Barry is a key member of the firm's pay equity group, advising clients on addressing pay disparities. Thank you both so much for being here today, and we're very much looking forward to this discussion. So I will hand it over to Kristen to get us started.
Thanks so much, Mike, and for the honor to be here with you all today. We know how busy you are and how many things you have to deal with in your industry, and employment counseling and matters are just one of the many areas of rapid change that your industry is kind of forced to deal with. I'm honored to be here with my partner, Barry Miller, who is really the guru in this space. And as you'll hear him describe throughout the remarks today, has really been tracking this and influencing the legislation, being a part on behalf of the business community and this Health and Hospital Association, making sure that the voice of business is heard when legislative changes like this occur. We're here to talk today, if you turn to the next slide, please, about, well, this slide just is our legal mumbo jumbo, which you won't be surprised to see is our disclaimer that we're not here to provide legal advice. And we would ask if you ask questions, which we very much hope that you do, because we want this to be interactive. We just ask that those be anonymized and not personalized to a human or your institution, so that we can keep this at the appropriate level of discussion. But we want to talk today about the granularity of this new law, which is set to take effect at the end of the month and does require some change in your organizations to make sure you're prepared. As Barry and I were talking in preparation for the remarks today, given all that you need to deal with in Massachusetts as an employer and all of the regulations and laws that you must comply with, this is comparatively not so scary, we would say, and we hope that by the end of this half hour or 45 minutes we have together today, you'll agree with us. But this is very much in Massachusetts part of a trend. And, we're not a leader in this case, we're a follower here. But there are already, as you can see here, 8 states in which affirmative disclosure of pay levels is required, and 4 in which we know it's coming, not quite there yet. There are a few in which, if applicants request the data or in a job posting, states must provide that information on pay transparency. But we're here to talk today about what do you need to do imminently to get ready for these requirements taking effect in Massachusetts. We know most of you are handling employees at least in New England, if not in Massachusetts proper. So our focus today will be on this Francis Perkins Workplace Equity Act and the data reporting law. Next slide, please. As I mentioned, Barry has been involved Seyfarth has been tracking this pending legislation in various forms as it wound its way through legislative sessions over quite some period of time. There were multiple alternative provisions proposed, and the business community was heard from, including from Seyfarth on behalf of our clients in your industry and others. And where we landed is on a law that essentially has two pillars. One focused on providing transparency in pay, and the other that will require employers to modify the way in which they report pay data. And for the details of that, I'm going to turn it over to Barry to get us started and roll up our sleeves and better understand what we need to do next. Barry?
Thanks, Kristen. I'll just say a few more words to put in context the substance of this law, which we'll talk through in detail. We'll go through all of the relevant provisions, but some of the background points that Kristen mentioned are really salient here, because in Massachusetts, when we have a new law that regulates the employment relationship, we usually look around and expect that it's going to be very bad for business. And in this space in particular, this broad world of pay equity, pay transparency, Massachusetts had been a leader, particularly in 2018 when the legislature substantially revamped the Mass Equal Pay Act. It was a very progressive measure that put Massachusetts ahead of most other states at that time and imposed some fairly stringent requirements on employers. And at that time, there was almost no discussion in the legislature about the impact that the law would have on business. There was just generalized celebration that Massachusetts was doing something to promote pay equity. And this legislation has followed a very different course, because there really was substantial disagreement among folks in the legislature as to how this should work. And industry groups got a seat at the table in the discussion of this law in a way that I have not seen in 20 years of practice in Massachusetts. And where that leaves us is with a law that is somewhat balanced. We'll talk through some of the provisions. But for those of you who operate in multiple states, it's worth thinking about how this somewhat moderated Massachusetts law relates to other jurisdictions in which you're going to be posting jobs. Because fundamentally, I think for all of you, the task at the end of the day will be to come up with an approach to complying with these statutory provisions that balances all of those requirements and allows you to address this issue of pay transparency without doing it on a state-by-state sort of whack-a-mole basis, which could really be an administrative nightmare for folks. So with that, we can dig in on the next slide. And as Kristen mentioned, there's really two fundamental pieces to this legislation. At the end of my remarks, you might think there's actually just one, but this one is genuine and real. This is the fundamental pay transparency provision of the law. And pay transparency at large just means you need to say something to your employees about what you expect to pay for a given job. The statute is really broken into two separate pieces. This piece of it becomes effective October 29, 2025. For any of you who may have been monitoring this issue in the press, you'll actually see different information out there. Many folks are reporting that the effective date of this statute is July 31, 2025. That's not the case in our view. Some folks seem to have not taken into account the fact that the effective date of this statute, which is a legal term, was 90 days after it was signed by the governor. So the effective date of the statute, while it was signed on July 31, 2024, it's effective in October, and these pay transparency requirements in the statute come online 1 year after the effective date. So the compliance milestone that you all need to keep in mind is a ways out. We have a year to get our game together to deal with this, and we may, in that period of time, see additional guidance from the Attorney General on this. The Attorney General has been very active in the pay equity space and has issued quite a bit of guidance on the pay equity law that came across in 2018. It would be not surprising to see the AG chime in on this subject as well, which may be helpful to folks as we get closer and closer to the compliance date, because there are a couple of open questions. But in broad general terms, these pay transparency requirements apply to any employer with 25 or more employees in the Commonwealth. That's nice and clear. A lot of the employment laws that we've gotten recently are less clear in scope. If a law requires that you have 50 employees, it's sometimes ambiguous as to whether you count folks who are not in the Commonwealth or only your Massachusetts employees. Here, there's a clear bright line test. If you have 25 or more people, at the time that you make a job posting, you need to comply with these transparency requirements. Those requirements are summarized in the third bullet below. The fundamental obligation here is that in any job posting, which is a statutory term of art, you must disclose a pay range for the position. And there are two definitions that really crystallize what that means. And this is where you begin to see the difference in approach between the Massachusetts statutes and some of the other statutes that have come online up to this point. First of all, we have a definition of a pay range, which is the annual salary or hourly rate that the employer expects in good faith to pay for the job. That seems straightforward, but it excludes a lot of stuff that is helpful from the employer's perspective. It doesn't include bonuses. It doesn't include benefits. It doesn't include other compensation, incentive compensation, and perquisites. And that might seem like common sense, but many of the other statutes that have been passed up to this point do not take that approach. For example, the pay transparency law in Washington State, which is one of the few most far-reaching, requires that employers disclose a general description not only of salary or hourly pay, but of all benefits and compensation that go along with the position. And some employers have really struggled with how to describe particularly a range of incentive compensation, which could be wide open if you think about a discretionary bonus. And it could depend on the performance of the company in addition to the performance of the individual. And so employers that are doing business in states like Washington and Colorado that have these more far-reaching requirements are already having trouble coming up with a description that they can abide by in terms of incentive compensation or benefits for a particular role. And the upshot here is we don't have that problem. All you need to disclose is base pay. You may need to come up with an approach if you want to have a homogenized national approach to pay transparency that says something more. And you may decide, either for recruiting purposes or to just simplify your approach, to provide more information than that in your job postings, but it's not required. A second limitation on the scope of this first provision is that not just every mention of a job is a job posting for purposes of the statute. What it refers to is a posting for a particular and specific employment position. Those words come straight out of the statute. We know that that applies whether the employer is posting something, for example, on its own website or going out to making a posting on Indeed, or if an employer enlists a third party to make a posting. But the specific and particular provision aspect of the law does give an employer some freedom of movement such that you don't have to spit out a pay range every time you mention the notion that you might hire someone. For example, if you just put a help wanted sign in a store window, or you put something on your website that says our company is recruiting and hiring for a wide range of positions without mentioning any specific job, then you could solicit resumes that way without posting this pay transparency information alongside it. But you do need to be careful, because if you put a help wanted sign in your store window and what you really mean is we're recruiting for a specific and particular position, i.e. a cashier, then you may need, even in that help wanted sign in your window, to include some of this pay transparency information. So that's kind of the foundational piece of pay transparency, is to post it in these job ads, but it's not the end of the story. There are two other situations in which you may need to disclose a pay range for a job. The first is that if you offer a promotion or a transfer to an employee in a way that affects their job duties are going to change in some way, you need to provide the same pay range disclosure to that employee who's being promoted or transferred regarding their new position, as if you were posting that out in the world as an open position for which you were going to hire. Probably not a huge additional burden for most employers, but a technical compliance point that you may need to keep in mind. This third piece, on the other hand, is a little bit tricky, because in addition to your job postings and providing disclosures in conjunction with any sort of promotion or transfer, the law also requires an employer that's subject to these requirements to provide the same pay range information upon request from an incumbent employee or applicant. And at first blush, that might seem pretty innocuous, but it has some ramifications that you're going to want to prepare for. First of all, because incumbents can request the pay range for their position, you don't need to be prepared simply to provide a pay range for new jobs that you're posting and looking to fill. You have to be in a position to relatively quickly come up with a pay range for any and every job in your organization, even if you have no plans to recruit for it. And that's the sort of thing where inertia can kind of build on itself, because when we're counseling employers regarding these sort of pay equity, pay transparency matters, and we're talking to organizations where employees are beginning to chatter among themselves about pay equity, which happens a lot. Employees will often talk amongst themselves about these issues before they raise them to HR, before they raise them to their managers. And that can be a real drag from an employee relations perspective, because if you have everyone in your organization requesting the pay range for their role, first thing you're going to have is the headache of compiling all that information and distributing it out to people. The second is how they're going to react to it, because especially with rapid inflation over the past few years, really low unemployment numbers, and a demand-driven economy for jobs, people who are hired more recently are going to tend to be paid significantly more than people who were hired 5 or 10 years ago, just as a result of economic trends, if your organization hasn't accounted for that. And so if you have a lot of incumbents asking for the pay range in their position, of course, the subtext of that is almost everyone assumes that they should be at the top of the range, right? And so when an incumbent sees the pay range for their role and recognizes that they're not at the top, they're in the middle, or maybe even below the 50th percentile, you may have a lot of static to manage among your current employees without even thinking about any job posting requirements that come about as a result of these statutes. And with that, I think we can move on to the next slide. So I've laid out the general requirements of the statute, and there are a few things that go along with the pay range disclosures that organizations should begin doing now or begin preparing to do soon in order to be in a position to comply next October. And one way to think about the compliance puzzle that's posed here is where the challenge is going to come from. It's going to be pretty clear whether or not an employer has posted a pay range in the job posting. There's not going to be a lot to fight about there. I also don't anticipate that there's going to be a lot of fighting about whether a job posting is about a specific and particular position. That's usually going to be relatively evident from the posting itself or from the surrounding circumstances. What folks are really going to be fighting about, and we've seen this in the states that were sooner to this dance than Massachusetts, is whether the range that an employer has posted is in good faith. And we've seen some, call it cute behavior from employers that are subject to similar requirements in other states. For example, one marquee employer got lit up on Reddit for posting a job with a salary range from $90,000 to $900,000. And obviously that sort of extremely broad range that would incorporate not only the full pay range for a given role, but probably for your whole company, is not likely to meet the good faith requirements that go along with this pay range disclosure. We don't yet know, and we may hear from the Attorney General something more about this, what good faith specifically might mean. For example, we don't have a quantitative test for that the pay range has to be within 10% of what you actually pay for the job, or somehow calibrated to what you're actually paying the incumbents in the job. We don't know that. We do know from some of the early litigation that has started to percolate from the 2018 amendments to MEPA, that good faith is subject to two very different perspectives. We've seen summary judgment decisions in the pay equity context, which also involves a good faith determination in terms of whether an employer has conducted a good faith pay equity analysis. In some cases, the courts have said good faith is difficult for a judge to assess and may necessarily be a jury question, which is a problematic interpretation of the law from the employer's perspective, because it basically means that any and all disputes about this would require a jury trial. But there's an important footnote to that you'll see coming up. The flip side of that coin is a recent decision that involved the Commonwealth as an employer, in which the court said bad faith just means the absence of good faith. And that's a radically different way to interpret that sort of requirement, because it basically means if there's no overt indication that you're trying to lie, cheat, or steal, what you've done is sufficient. That may still not get you under the umbrella if you're posting a range that goes from $90,000 to $900,000, but we're optimistic, based on the general design of this statute, that employers will get a little bit of leeway as to what constitutes good faith, especially as we're all trying to figure out exactly what this statute means. So how do you get to good faith? It's going to be essential, not really for purposes limited to the pay transparency requirements, but really because of the larger picture of increased regulation over the way that employers pay people. It's going to be necessary for most employers of any real size to have a job architecture, a salary structure that will provide a framework for the pay range for a given job, so that you're not just making this up or surveying your empirical pay range every time you get an inquiry or have to make a posting. That sort of infrastructure really, I think, for many employers, and certainly for large employers and most healthcare institutions, is going to be critical to complying with this statute. And nothing new and innovative, or at least rocket science level innovation, is required here. Likely, what you're going to look to for the pay ranges that you'll post in your job postings will be something like a salary band. And we've certainly all seen those. That raises the natural question of, do you have to post, or should you post the full pay range for a position? Should you post that full salary band? If you've got a VP role and your salary banding says a VP could make anywhere between $75,000 and $125,000, is that what you post? And the answer to that is not necessarily, because we need to take into account these legal requirements to make a transparent disclosure, but we also need to take into account the employee relations considerations that I mentioned previously. How is your current constituency going to react to this pay range that you post in the job? And you want to think about the obvious recruiting angles. Generally, posting a higher pay range is going to be bad for employee relations and good for recruiting. And so you're going to have to find that balance. But in doing that, one thing to keep in mind is that you can calibrate within, for example, a salary band. And instead of posting the full thing, the full range of that band, you might post the midpoint plus or minus 20%, or you might post something like the 40th percentile to the 60th percentile. And that's going to have to be a decision that each organization makes for itself based on all of those considerations. That raises a natural question of, if I post a range and I've engaged in some good faith analysis to get to that range, how limited am I if I get some unicorn candidate that either demands more compensation or I think I need to reel in with an offer that exceeds the pay range. And experience from other states suggests that's not a huge hiccup, so long as the pay range was undertaken in good faith and you can tell a story about how you got to the range that was posted in your job ad. If you end up paying a highly qualified candidate more than that, shouldn't be a per se violation of the law. However, you also want to think about a pattern that may emerge, because your employees will be watching what you do in this space. And in fact, that's the design of this statute. It's called a pay transparency law for a reason. It's intended to give employees much more information than they've traditionally had about what the organization pays people in general and not just themselves. And so if you develop a pattern of hiring above or even conceivably below the stated range in your job ads, where you're consistently hiring outside the stated range, you're going to open yourself up to the claim that those ranges are not stated in good faith and that you're not compliant with the statute. And so as you get your program up and running, in addition to being mindful about setting the pay ranges in the first instance, it's probably a good idea every once in a while to review the offers that have gone out and see whether the offers you're making are actually within the range that you're stating in your job postings. And if so, where within that range are they? Are you always hiring people at the top end of that range? If so, good faith might require that you recalibrate the stated range to not suggest that the job is likely to pay less than you're actually offering people to take it. And all of those points boil down to the notion that good faith may be contextual. In other words, an employer that is large, has substantial resources, like many healthcare employers, and has a compensation team, a large HR department, lots of analysts and accountants. An organization like that may be held to a higher level of rigor and accuracy in setting a pay range and posting it in a job ad or disclosing it to an employee than something more like a mom and pop operation that's just barely over that 25 employee threshold and doesn't have neatly defined parameters around each role in terms of the duties, the qualifications, or the compensation. You may need to sort of adjust for your own organization's realities in assessing what constitutes good faith. So that's pay transparency. The next giant pillar, of course, is the pay data reporting, but we have at least one question that's come in thus far. And the question is whether an employee can request a pay range for a position that they're not qualified for. Or can an employee just ask for a pay range for any position within the organization? And the answer to that is a qualified no. What the statute allows is for an incumbent or an applicant in a role to ask for the pay range for their position. You don't get to ask for your boss's pay range or the CEO's pay range. But as mentioned, when you have coordinated activity among employees, you may see them working together to request pay ranges for multiple positions. But if you get a direct request for an employee from an employee for a pay range that is not their job, and it's not a job that they're applying for internally, you don't have an obligation to provide that. From an employee relations perspective, you'll have to make your own decision about just how transparent you want to be, because of course you could. If you have a junior engineer 1 and he or she requests the pay range for junior engineer 2 in thinking ahead to his or her career, maybe you want to disclose that information, but you're not obligated to do that. Okay, so I think with that, we can move on to the pay data reporting piece, which is the next slide. This is the second major pillar. So we're putting pay transparency away for a minute, and we're talking about an entirely different subject matter. As you'll see from the criteria on the slide, it's a completely different scope. While it's part of the same bill, it amends a different statutory provision and is almost totally independent of everything we've talked about up to this point. And the threshold for the pay data reporting piece is that it applies to employers with 100 or more employees in the Commonwealth at any time during a given calendar year. Again, a nice bright line threshold. And one thing you'll have to keep in mind is that any time during the calendar year piece of it, because if it comes time to submit reports and you've dipped down to 80 or 90 employees, but you had 100 a few months ago, you may still be subject to this requirement, even though you're not above that threshold at that time. And there are two pieces. One, you have to have that number of employees in the Commonwealth during a given year, and the statute is clear that it only applies to employers that are subject to federal wage data reporting. And for most of you, that's going to be an EEO-1 form. The statute ropes in a couple of other reports, EEO-3, EEO-4, EEO-5. Those are niche and apply only to local unions and state and local governments, not likely to be a problem of yours. But it's worth noting that a lot of the companies that at least have a toe in this sector aren't going to be subject to any of those requirements. For example, private universities don't file any EEO form. And so they're just not subject to this law, even though pay transparency and pay equity are very hot topics in the university context. Simply doesn't apply here. And it's notable that the compliance date for the pay data reporting piece is actually sooner than the pay transparency piece. Pay transparency comes online next October. In theory, pay data reporting, the first reports from private employers are due February 1, 2025. That third bullet refers to the other EEO-1 forms that I mentioned, and one difference is that folks who file those forms are on a biannual schedule. They don't have to do this every year, but for most of you, for most private employers, you're going to have to file these reports, and essentially these reports would involve providing compensation data by role and by gender for essentially all of your employees on an aggregated and roll-up basis. And with that, we can go to the next slide, because more specifically, the pay data reporting piece of the legislation is key to so-called component 2 EEO-1 data. And for those of you who have been involved in the filing of EEO-1 forms, you'll remember some amount of a dust-up starting about a decade ago when the EEOC first started collecting component 2 data. And without that, with just component 1 data, an EEO-1 form is a relatively simple document. But component 2 is where the EEOC started collecting the pay data that I mentioned, and it turned into a sprawling exercise for organizations of any size. Ironically, the EEOC, in promulgating that requirement, had to provide an estimate of how much time it would take an average person to complete this new paperwork under the Paperwork Reduction Act provided by federal law. Their estimate was 15 minutes. And anyone who went through this exercise knows that it's days and days of work. And as a result of that and other considerations, the EEOC during the Trump administration just stopped doing it. They just suspended the collection of component 2 data. And under the Biden administration, there's been no effort to revive that. Everything about the pay data reporting requirements in the Massachusetts law is keyed to this data that the federal government does not collect. And so in most respects, the pay data reporting piece of this is a nullity unless and until the EEOC restarts the pay data reporting collection. My own view is that the EEOC is likely to give you a decent ramp, give employers in general a different ramp before it just flips the switch back on to collecting component 2 data, because as mentioned, it can be a very significant exercise for a lot of employers. And unless and until that changes, I see no statutory basis for the government to even attempt to collect this pay data reporting from Massachusetts employers. Now, there are other voices in the dialogue. I've attended a few conferences like this one at which folks have suggested that somehow the Attorney General or other representatives of the Commonwealth are going to find a way to work around the fact that the EEOC is not collecting component 2 data. And so we may see litigation or at least discussion on that point, whether the Attorney General even can impose this requirement when the EEOC is not doing it. But up to this point, our best read of the statute is that employers simply don't need to do anything until the EEOC restores that data collection process. So that's the second major pillar of this new Francis Perkins workplace law. The last thing that we want to talk about before we go into a Q&A is the enforcement and penalties provision. We can go to the next slide for that. This is sort of a distillation of the points that we've been talking about all along and that Kristen mentioned at the beginning. There are features of this statute that really do reflect a kinder, gentler approach to the regulation of the employment relationship. And that starts with the fact that there's no private right of action. There will be no class action lawsuits. There will be no individual lawsuits where folks are saying, hey, I saw your job ad in the paper. You didn't post a pay range. I want to collect some sort of bounty for that. And that is in sharp contrast to some of the other statutes that have been passed. For example, I mentioned Washington already, and we're starting to see class action lawsuits in Washington where the statute provides not only a private right of action, but a minimum penalty of $5,000 per violation or actual damages, whichever is greater. And there's already a flood of class action lawsuits on that front. Some of them are directed at employers that just inadvertently or negligently didn't post a pay range with the job posting, but many of them are based on the theory that I mentioned before. You've included pay range information in your job posting, but it's not in good faith. It's too broad, or it's not what you actually intended to pay. And those early lawsuits, many of them are resulting in settlements. Employers are choosing to settle those claims, often for significant money, rather than fight them out in court. We're not going to have that problem here, at least until somebody amends the statute. And so the business lobby really did us all a huge favor in that regard. Now, that doesn't mean that we have a get out of jail free card. This statute is set up to be enforced by the Attorney General. So it's similar in orientation, for example, to the personnel record statute, which doesn't afford a private right of action. But if a Massachusetts employee requests their personnel record and you don't give it to them, they can complain to the AG, and the AG will come shake you by the collar and tell you to give them their personnel record. This is going to be similar. And there are several features of the Francis Perkins statute that evince a very specific intent not to be punitive. So in addition to the fact that enforcement is entrusted to the Attorney General exclusively, there are several statements in the statute that treble damages does not apply, which is odd in several respects. The first being there's no conceivable way that treble damages could apply to something like this. But the legislature, as aided by the business lobby, nonetheless went out to insert several places in the statute a specific statement that this is not that kind of statute. So if the Attorney General elects to enforce the law, and we have seen the Attorney General enforce similar laws, the personnel record statute is one, the sick leave law is another one that's very front and center on the Attorney General's radar. But their approach to enforcement is very different than private litigation. Particularly with a statute like this, the Attorney General is almost always focused on ensuring compliance and making sure that people comply with the law, as opposed to pursuing these things based on a profit motive and looking to get rich on them. And consistent with that general approach, the statute actually builds into it a guarantee that an employer that violates this law gets one free warning. And that doesn't even require the employer to show that the violation was inadvertent or anything like that. Even a willful violation of the statute, the first offense, maximum penalty is a warning from the Attorney General. And from there, the Attorney General can impose civil fines, which start at $500 for a subsequent offense after an employer has received a warning, and can scale all the way up to $2,500 per offense. And that math can be a little bit deceptive because there's some multiplication that could occur. Offense is defined in the statute to be all of the non-compliant postings an employer makes within a 48-hour period. And so, for example, if your HR folks push a button and upload a bunch of job postings to Indeed and fails to include a pay range for that group of activity. However, if it takes a while for anybody to get around to calling you out on the fact that your job ads are non-compliant, this could add up in a really serious way, because if you have weeks and weeks worth of postings out there that do not have a pay range in them, then for every 48-hour period, you could be subject to a $2,500 fine. So there is the potential for large-scale liability here, but it should be pretty easy to avoid with the sort of practices that we've talked about. And one thing to keep in mind on that front is that the Attorney General's enforcement of virtually all statutes is complaint-driven. They simply don't have the resources to go scouring the internet and calling up employers that don't put whatever may be required in a job posting. And so that employee relations aspect is there as well. You know, the way that the Attorney General is going to show up at your doorstep is not necessarily because you failed to include a range in a posting or that you failed to give it to an employee who requested it. The AG is going to come knocking one step later in the process when the employee or applicant doesn't get what they believe they're entitled to, and then files a complaint with the Attorney General. So you have that much more distance between you and aggressive Attorney General enforcement. And that covers most of the material we wanted to get out to folks today. I think we can open it up for some questions at this point. Mike, did you want to join us for the question and answer portion?
Yeah, and there's a few here posted in the chat that Kristen or you can work through. One I see here, are there any exceptions to the posting requirements, such as might pertain to highly compensated senior leaders or physicians?
Yeah, good question. Answer, no. There are no exceptions to this at all. So if you were to post, for example, a job for your CEO, you'd have to post some sort of pay range for your CEO. The backdoor trap there, of course, is that you don't have to post for some of the senior most positions in your organization. For example, if you just go to a recruiter and say, find me a CFO, and the recruiter mines his or her network, but you haven't posted something out there in the world that says we need a CFO, then you're not going to have to disclose that pay range. But if you do make a posting, there are no exceptions to the pay range requirement.
Another one here is, I guess, is it the expectation that the range that would be provided to job postings be identical to that would be offered to those internally who are potentially seeking promotion or transfer?
Yeah, it would be difficult unless there's some difference in circumstance to justify providing a different range to an incumbent versus an applicant for the same role. Now, if an incumbent requests a pay range today and 6 months go by and you are posting a pay range for a similar job, but the scale is different for whatever reason 6 months from now, then there would be a way to understand that discrepancy. But if you're telling different people different information about the same job, you're going to have real trouble meeting that good faith requirement. That would be one of a few ways to really put yourself at cross purposes of that requirement.
And just for clarity, knowing that hospitals often, advertise both nationally and internationally for positions, this applies to job postings anywhere and not just those in Massachusetts, correct?
No, it should apply only for roles in Massachusetts. That's not stated in the statute, but it does appear to be the design. It's a good question because one of the big issues that has come up in this space is Colorado's approach to this. Colorado takes the position that if a job could be performed in Colorado, it's subject to their statute. And so if you post a remote role, Colorado says we get to regulate that. That led some employers to post job ads that said this job is open to everyone except residents of Colorado, which the agency did not receive well. But we don't have that issue. This is not an attempt to regulate anything that's going on outside the borders of the Commonwealth. It's just for jobs here in Massachusetts. But if it's a remote role and you have an expectation that the incumbent is likely to be in Massachusetts, then you may want to consider making a disclosure just to be on the right side of this set of issues.
And, several years ago, Massachusetts adopted a pay equity law here in the state. What sort of interaction is there between this posting requirements and that prior pay equity law?
Yeah, all of these statutes, all of the provisions of the Francis Perkins Act and the revisions to the Massachusetts Equal Pay Act in 2018 are designed to do the same thing fundamentally. The identified problem that the legislature sees is that women are paid some cents on the dollar less than men in the economy at large. And that's what the pay data reporting piece was intended to flesh out. And it's intended to put the Commonwealth in a position to report sector by sector in the economy, how are women paid relative to men, if and when there's ever a regime in which they actually get that data. And the pay transparency piece is tied right into the Massachusetts Equal Pay Act in attempting to disrupt the balance in information between employers and employees. For example, in the Equal Pay Act, one of the provisions is an admonition that employers are not allowed to ask applicants what their salary history is. They're not allowed to ask, what are you making now? What did you make at your last job? And that was because the legislature saw an informational asymmetry there that put employees, in theory, in a lesser bargaining position relative to their employers. So you see in 2018, the legislature trying to adjust that balance, give employers less access to certain information that they were using in this process. And the flip side with this pay transparency legislation is to give employees and applicants more access to information about how an employer is going to pay them. So that's one close alignment. Another close alignment is that the employer's response to this most recent legislation is essentially the same architecturally as the revisions to the Massachusetts Equal Pay Act. In other words, all of these laws, all of these provisions put a huge premium on an employer not only setting up a job architecture, but understanding how they're paying people and doing an analysis of their own pay equity situation before the Attorney General comes knocking, before an employee files an equal pay lawsuit. In general, you just have a massive increase in rigor around your pay setting that pervades this entire statutory scheme.
Barry and Mike, I see one other question is sort of how do incumbents need to request the range? Like how do you go about it? And I there's no magic answer to that. I mean, you should be on the alert, employers, for these kinds of requests. As Barry said, we could see this become part of a campaign or strategy by employees to, to gain information for one thing, and potentially to create employee relations challenges. But there's no magic path that an employee needs to follow in order to get at this information. So you want to be focused on training, within the next year, your managers and recruiting talent and so forth to understand the parameters of this, and to be on the lookout for those kinds of requests. Barry, anything to add?
No, I think that's just right.
Mike, any other questions?
No, I think that's it. And we're actually running over time a little bit. Thank you very much to both of you. A lot of great information in here. And I'm guessing as we get closer to sort of the go live here that we'll get some more questions flowing in. Maybe it'll occasion an opportunity to revisit with both of you. But thank you very much for joining us today. And thank you, everybody in the audience. Put a QR code up here. If you scan that, you can see all of MHA's upcoming educational programming. We have several events in the near future, and then we hope to see all of you again very soon at one of them. Kristen, Barry, thanks again for a great session. Thank you, everyone, for joining us. I hope you all have a wonderful afternoon.
Thanks, Mike. Take care.
Thanks.